glad that you're here. Again, I'm Teresa Phillips. I work at Forster Bowman. Great part of my practice is probate and guardianship litigation matters. And if you've been joining us lately from your webinars, you'll see that we've been focusing on guardianship matters as they are a trending topic this day in the law. They become part of the pop culture with Netflix shows and documentaries and things of that sort, and the Brittany Spears sort of front page stories. Florida's a elderly person's haven. We have a lot of those folks here that come for retirement, and as guardianships are for anybody who has incapacity, it is no secret that it's usually the elderly that are subject to them. And so there's no wonder why it's such a hot topic here in Florida. So the purpose of this webinar, part one, and then part two we'll show you next month, is to kind of look at what it says in the title, a trend that's rather disturbing, a trend that where guardianships are not always being used for good, but can be used for nefarious purposes, or where things break down in the guardianship and arguably does more harm than good. We're going to break it up in two parts. This first part is going to focus on the statutory scheme, how the guardianship works in Florida, so we have a basic understanding of that. And then part two is going to get more into why things go wrong and try to look at why there's room for corruption or malfeasance or neglect and things of that sort in the system. And we'll look, as always, we'll take a look at some of the recent, articles that are in the news, the cases that make the news, and the cases that grab everyone's attention when things do go wrong. So if you've been to one of our other webinars on guardianship, we probably went in more detail on the statutory scheme and the different parts of that. Today we're just going to do a nuts and bolts cursory review of that and highlight some topics to lead us into part two, where we'll delve more into why we're seeing this disturbing trend. So with that, let's start looking at our agenda for the day. So the first part we're going to look at is the Florida Guardianship Code. We're going to, like I said, look at the nuts and bolts. We're going to look at the purpose of the code, what it's supposed to be doing, what the goals are. We're also going to look at the basic statutory scheme for how guardianship proceedings work. We're going to look at what protections are in the statutes for the ward, and then we're going to look at what safety nets are put in there as well. I'm going to note a ward is technically someone who's already been declared to be incapacitated. Before that point in time in the guardianship proceedings, we usually use the word alleged incapacitated person or vulnerable adult. But for purposes of today, I'm going to use the word ward to mean anytime we're talking about someone who's subject to a guardianship proceedings, even if maybe they haven't yet been declared incapacitated. In section 2 of our agenda today, we're going to look at factors that affect how successful a guardianship will be. Four of those main factors are going to be whether there's any of the pitfalls, the common pitfalls that are in place. We're going to look at sometimes it's the type of guardian you have, professional versus personal or individual guardians. We're going to look at what the costs are involved in guardianship, which can affect how successful a guardianship will be. It can be so costly, it can cause such financial harm to the ward that sometimes you have to ask if the benefits outweigh the cost. And then finally, we're going to look at lack of judicial oversight and how that can play into how successful a guardianship will be. The final section, section 3, and we're just going to highlight some of the guardianship horror stories, and we're going to look at some local ones and then some across the United States. And while we probably won't have time to just delve into them in any detail, I'm going to give you some links. And the ones across the United States, I think sometimes people don't believe that the trend is as unsettling as we warn. But you literally can find any state that has had similar problems and it's becoming more and more of an issue, and I'll give you some links and some citations to those, and if we have time, we'll go through some of the factual situations and how they ended up being horror stories. Okay, so that's our agenda. With that, we'll get on to section 1, and we're going to delve into what the Florida Guardianship Code looks like, and how we end up with guardianships. So first, why do we have a Florida Guardianship Code? All 50 states have some kind of guardianship. Sometimes they're called conservatorships or some other name, but they all have some kind of statutory scheme whereby if someone's incapacitated or have some kind of legal infirmity that keeps them from taking care of themselves or their property to a certain extent, there's some kind of scheme in place to put somebody, a third party, in control. And here we call it guardianship, most states do. And I think anybody would agree the general purpose of that is to protect, to try to protect the person that is infirmed, incapacitated, or subject to harm. But our Florida Guardianship Code set forth some more detailed intent statements in the code itself, and I think they're important to understand and go through so that you understand what the judge, what the parties, the guardian, the attorneys involved should be considering when deciding to set up a guardianship or not to set up a guardianship for a person. So you find the legislative intent at section 744.1012 Florida statutes. And it states the findings of the legislature that led to the adoption and or the various revisions to chapter 744, which is the Florida Guardianship Code. So the first one here is they note a deprivation of civil and legal rights is disfavored unless necessary. So anytime you're in a guardianship, you should keep in mind it's not the favored finding, it's not the favored thing to do if there's something else, unless it's absolutely necessary, and that finding should always be the forefront of any guardianship proceedings, that this is a necessary thing to do before any civil or legal rights are taken away. The second one is the least restrictive means should be employed, and that falls in line with the first one, going along with whether it's necessary. If there's a way to protect a vulnerable or incapacitated person short of a guardianship, that means should be employed. Sometimes this can be if there's been good pre-planning done by the ward, and there's things in place like a trust, a power of attorney, things that protect the financial aspects of the ward's life, and if the ward has either a caregiver or a spouse or someone who can who has the legal means through similar powers of attorneys or what have you to take care of their person, make medical decisions, things like that. Sometimes the judge and the judge is comfortable with the relationship that there's no real chance of someone taking advantage of the ward. The judge may find a guardianship's not warranted in these situations and doesn't want to impose some kind of court, review of what these individuals, what decisions they're going to make. And if that's the case, that would be an example of the least restrictive means. It also goes to even though someone's incapacitated, if they can do some of the things for themselves, there's no need to make a blanket incapacity finding. You can accept out certain things that maybe the ward still is capable of doing. The third one here is incapacitated persons should still participate in their own life choices to the extent possible. And we're going to look at some specific statutory provisions here shortly that encourage even persons who have been declared incapacitated, completely incapacitated, even persons who have a guardian to make all their decisions, that it's encouraged and that it actually gives them the right to participate in their own life choices to the extent that's possible and does not harm them. And I think, as someone who's seen these up close, has seen the impact guardianships have on people, I think that's important for a number of reasons. When I've seen when people lose control over their lives, they give up, and there's a loss of hope. And I think the legislature was very wise to include this as part of their intent and part of the protections for an incapacitated person. And so that's something that should be kept in mind when a guardianship is in place. and with the parties that are involved, whether they be guardians, the judge, or the attorneys that are involved. The fourth legislative intent set forth is that some wards do not have loved ones or the money to support a guardian, and in such scenarios, incapacitated persons should have access to public guardians, but only after court has considered lesser restrictive means. So public guardians are those provided by the state when certain people have no one that's willing to serve, or they don't have the assets to support a professional guardian. Public guardians are available, and they're regulated by the state as well. So now that we kind of understand the purpose, kind of understand what the legislature was concerned about, let's start looking at the basic statutory scheme. We get our Florida Guardianship Law from Chapter 744 and the attendant portions of the Florida probate rules. They constitute the statutory mechanism under which Florida courts have the power to determine if a person is legally incapacitated. And guardianships are a two-step process. First, there has to be a determination of incapacity. And there's a process that you go through with the filing of a petition by an interested party who in good faith alleges that they have reason to believe that the person is at least partially incapacitated. Oftentimes that is based on a doctor's diagnosis that they're suffering from dementia. It's based on personal observations of watching a loved one become confused, forgetful, leave the stove on, those kind of things. And then there's a mechanism whereby the court then appoints a three-party committee that goes out and examines the alleged incapacitated person and provides a report of their findings. And then there's also an attorney that's appointed by the court to represent the ward or the alleged incapacitated person during these proceedings. So that's the first proceeding that has to happen, because if there's no incapacity, there's no need to consider whether there should be a guardian. Now, step two comes after there's been a determination of incapacity, and they're not distinctive steps, meaning steps that are taken in, with a big gap of time in front of them. They're done, back to back. In fact, the court's not supposed to find incapacity until there's been an appointment, is ready to make an appointment to make sure that an incapacitated person is not left out there floundering. So if there is an incapacity determination, then the court will appoint a guardian after determining there's no lesser restrictive means available. Section 744.3215, subsection 2. This is sets forth rights that may be removed from a person by an order determining incapacity, but they cannot be delegated to a guardian. And those include the right to marry. If the right to enter into a contract has been removed, the right to marry is subject to court approval. The right to vote, the right to personally apply for government benefits, the right to have a driver's license, the right to travel, the right to seek or retain employment. Now, again, these are things that the ward is going to lose power to do, but they will not be delegated to the guardian. The guardian can't vote for you. They can't, retain employment on your behalf. They can't, obligate you to marry, things of that sort. So that sort of makes sense. But let's look at what rights can be removed, and then that the guardian will be, and which rights will be delegated to the guardian in most cases. Those include, and they're set forth under section 744.3215, subsection 3 of the Florida statutes. And those include the right to contract, the right to sue and defend lawsuits, the right to apply for government benefits, the right to manage property or to make any gift or disposition of property, the right to determine his or her residence, the right to consult to medical and mental health treatment, and the right to make decisions about his or her social environment or other social aspects of his or her life. A guardianship judge once said something I think very wise. Once you've lost the legal right to contract, you've pretty much lost the rest of these rights. You can't get in, hire an attorney and sue and defend lawsuits without being able to contract. You can't apply for government benefits if you don't have the right to sign off on statements, certifying things are true. Making gifts or making managing property is all about contracting rights and things of that sort. Determining your residence if you can't sign a lease, and even consenting to medical and mental health treatment is in and of itself a contractual kind of exercise. And then finally, to decide who's going to be in your social environment, including those people who will visit you, what kind of activities you're going to engage in. You can't sign up for things if you don't have the right to contract. But so that's always the biggest one. When you lose the right to contract, it becomes difficult to do anything else, because most interactions with third parties have some kind of contractual relationship. So, and then again, when you look at that, think how much power that gives the guardian. They can decide your social environment, and by deciding where you're going to live, and by extension, that can probably dictate who's going to be able to visit you in person, who's going to be able to be part of your life on a regular basis if they move you somewhere where it's not convenient. That would probably lessen your contact with other parties, and then they consent to medical mental health treatment that maybe you object to. They can consent to. So it's pretty sobering when you see exactly what rights a person's given up, and then not only that, but they're delegated to someone else. So did the Florida statutes also put in some protections? Yes, they did. You find those in section 744.3215, subsection 1. They provide a list of rights that the incapacitated persons retain. And those rights include to have an annual review of the guardianship report and plan. When a guardian's appointed, they have to file an initial report, inventory, and plan for the ward, including where the ward will live, what actions will be taken to ensure the ward is comfortable, is obtaining the necessary medical care, and things of that sort. And then annually they have to update that with information. And they have to share that with the ward, even if maybe you make the judgment call, the ward doesn't understand it, they still have a right to receive a copy of these things. The incapacitated person also has a right to have continuing review of the need for restriction of his or her rights. At any time, a ward is supposed to have the right to be able to file a suggestion of capacity and have a review of whether or not they're still incapacitated. I'm going to tell you from practical experience, though, when a ward has a plenary guardian, meaning they have control over every aspect of their life, financial and personal, it can be hard for the ward to find the resources and access to the persons to help them with this, even if they are capacitated. So that's something that needs to be considered I think, in the plan, to make sure that the person has access to people that may be willing to help them if they ever do determine on their own that they think they have capacity and would like to see this revisited. They have the right to be restored to capacity at the earliest possible time if they are so, if they're no longer so incapacitated. There should be no delay in that. They have the right to be treated humanely, with dignity and respect, and to be protected against abuse, neglect, and exploitation. Again, I think that puts a duty on the court and on the guardians to oversee and make sure that they're not put in a situation where they could be subject to abuse, neglect, and exploitation, and that includes keeping an eye on any facilities that you choose to keep the ward in, or keeping an eye on caregivers or anyone else that you give access to the ward. And they have a right to have a qualified guardian. The court can go through an appointment of guardian, and they can they can decide whether they want a professional or a personal. They can decide that they want a guardian that has certain abilities or skill sets. Any of those things, they should have enough knowledge and qualification that they're doing a good job for the ward. What are some more rights they have? To remain as independent as possible, including having his or her preference as to place and standard of living honored, either as he or she expressed or demonstrated his or her preference prior to the determination of his or her incapacity, or as he or she currently expresses his or her preference, insofar as such request is reasonable. I can tell you that someone who's involved in guardianships, this becomes a really tense issue. Wards want to stay home usually or they want to stay where they are. If they're living with a family member, they do not usually want to be removed to a facility, even if it's determined that they need to have 24-hour care because there's, because of memory or dementia issues, they may leave the stove on or do harm to themselves. And if the guardian determines that staying at home with 24-hour care is just not feasible, and they're told to move from that place, that can be a very big source of tension and contention with that the judge sometimes has to be involved in. They also have the right to be properly educated. I have to tell you, I've never personally experienced where a wards wanted to get some kind of education or get some kind of skill, obtain some kind of skill. But if they need that or want that, they have that right. They have the right to receive prudent financial management for their property and to be informed how their property is being managed. If he or she has lost the right to manage the property, they're supposed to be kept updated. They're supposed to have even allowed to put input into their financial management. If they've had a financial person they've used, for the last 30 years and they trust them, I think this kind of imposes a duty on the guardian to use that person if there's no reason not to trust them, or if they've not been involved in any mismanagement. There's always a duty to try to make them as comfortable and to have some kind of interest in the management of their property, or not interest so much as information. Also see that guardians have to give an annual accounting if they're in charge of the property, and those have to be shared with the ward as well. So they also have the right to receive services and rehabilitation necessary to maximize their quality of life. If they are suffering from some kind of infirmity, if there's some kind of therapy, rehab that can help that, maybe they've lost the ability to do certain things, but maybe there's programs or services they could use that they can facilitate, that can help their quality of life. For example, if they have memory issues, that doesn't mean they still can't interact with other people. They can't enjoy certain things. That maybe they can even take classes or programs that helps them, plays games and does things that helps them with their dementia and keeps their mind occupied. They have the right to be free from discrimination because of their incapacity. And that's obviously I think that's pretty self-explanatory. And they have a right to access the courts. Again, I kind of go back to that comment I made earlier. I think sometimes there's this belief, oh, you've been declared incapacitated, so the court doesn't have to listen to you. But we've seen at least 2 examples in here where wards have retained the right to petition the court and to access the court. So I don't believe that's an accurate statement. I hear a lot of even attorneys say that, but I don't think that's consistent with what these protections and rights that are set forth in the statute say. So now we know wards have some protections, and those are statutory. And we have some more here. My apologies. They also have a right to counsel. As I said before, the court automatically appoints counsel when there's an incapacity petition, and you can substitute that counsel. The ward can substitute that counsel at their request. They have the right to receive visitors and communicate with others. They have a right to notice of all proceedings related to the capacity and guardianship proceedings, unless the court finds the incapacitated person lacks the ability to comprehend the notice. The only time I've seen that happen is like when if someone's in a coma or completely, comatose or something of that sort. Usually the court doesn't want to make a, if they're just because they're, have forgetfulness or maybe some mental infirmities, court usually doesn't want to make a determination if there's any chance they can have ability to comprehend the notice. It's better to give them the notice. And finally, they have the right to privacy. And that's why a lot of things in guardianship proceedings and incapacity proceedings are confidential. Just because they've lost their legal rights doesn't mean that the whole world has to know what's going on, and that they lose the basic right to privacy. So I think that finishes up our statutory protections. And so now you see they do have kind of a list of rights, Bill of Rights, if you want to say, under the statute. Now let's look at section 744.3215, subsection 4. That lists out what a guardian may not do without first obtaining specific authority from the court. And those include commit the ward to a facility, institution, or licensed service provider without formal placement proceeding pursuant to Chapters 393, Chapter 394, Chapter 397. They cannot consent on behalf of the ward to the performance on the ward of any experimental, biomedical, or behavioral procedure, or to the participation by the ward in any biomedical or behavioral experiment. The court may only permit these if it is of direct benefit to and is intended to preserve the life or prevent serious impairment to the mental or physical health of the ward, or it is intended to assist the ward to develop or regain his or her abilities. They also cannot initiate a petition to dissolve a marriage for the ward without court permission. The guardian cannot consent on behalf of the ward to termination of the ward's parental rights. And finally, the guardian cannot consent on behalf of the ward to the performance of a sterilization or abortion procedure on the ward. I think most of those are self-explanatory. They're rather extreme, probably not things that come up very often, and you can probably understand why the legislature would want the courts to be aware of this and to give specific consent before permitting any of these rather extreme things to happen solely, at the guardian's institution, as opposed to if the ward did it himself. So let's look at what the built-in statutory safety nets are. Well, we went through a good list of them, the statutory requirements. As you can see, it goes from having mandatory petitions and hearings held, and the court having to make specific findings as it relates to capacity and whether a guardianship is even needed. Having the procedure set forth, having the court's participation, and then having all these other the rights, protections, and restrictions on the guardian all would constitute, I think, statutory safety nets. They're intended to keep something bad from happening. You also have guardians have to post bonds in most cases. That's in case there's any kind of financial misappropriation or malfeasance, and that's depending on the assets, usually determines the value of those. The court can use restricted depository accounts to also try to ward off financial mishaps by the guardian. What happens here is there's a statutory scheme where banks can set up a restricted depository account, and they will do so if the court has ordered that. And any proceeds, money proceeds you receive, the court directs that they be deposited into this account, and it limits the withdrawal power of the guardian. They can only withdraw with a court order, or if the court already enters an order that pre-approves certain types of withdrawals or debits, then the bank will only honor those, and they will only honor the ones where you have a court order. There's no coming in making withdrawals, cash withdrawals. There's no making payments to anything other than what the court has approved. Most counties and circuits use court auditors and monitors to assist the judges in their review and oversight of guardianships. Auditors will help with checking the accountings every year. They will check annually to make sure that the guardian is in compliance with filing reports and anything else that they're required to do. Court monitors are used sometimes, and they can go and do research for the judge. They can actually, the judge can give them subpoena power to go out and get bank records or get anything that the court may want to look at. And they can also do, search, reach out to guardians, reach out to interested parties to see if there's any areas of concern that the judge might want to address. And that all leads us up to probably the most important safety net, the judicial oversight function. As you can see from the scheme that we went through just now, judicial oversight is the ultimate, protection. The judge is brought in at least annually to review things. The judge has to be consulted to do certain things with the ward and make sure that the guardian's complying with law and with the court's order and doing things in the best interest of the ward. And the court obviously is the person that the ward will go to or should be able to go to and have access to if they believe they have capacity or if they have any other issues. So these are sort of the built-in safety nets that the legislature intended to help try to minimize any risk of harm to the wards. So now that we kind of understand the statutory scheme we're looking at, let's move on and look at factors that you need to look at in any particular guardianship, and that will probably give you a good idea of how successful a guardianship will be. So these are what I call pitfalls. If you start out with any of these issues, you're going to have probably a troublesome guardianship in some extent. And again, I would define a successful guardianship by one that where the guardian is in better shape and is protected and everything's been in the best interest of the ward, and where there's more good than harm. An unsuccessful guardianship is one where there's been more harm than good that comes to the ward as a result of the guardianship. And here are some of the pitfalls that I've noted and that I look for in any guardianship I get involved in to kind of feel out how I think I'm likely to have a successful guardianship or not. One is a bad faith petitioner. All of this starts with the petition. Someone has to petition the court to determine incapacity and appoint a guardian. The system kind of and the structure of the scheme that we have needs a good faith petitioner. If the court's acting on bad information, false information, incomplete information, key omissions, then things may be ordered or entered. Orders may be entered that do more harm than good. A bad faith petitioner is someone who is not filing the petition because they believe the person's incapacitated or needs protection, but because they want, but for some bad faith reason. That could be they're wanting to control the ward and or the ward's assets. They could be at odds with the ward and want to get some kind of advantage by putting some kind of idea out there that the ward is possibly incapacitated. If any of those things happen and the information that the sworn information that's being presented to the court it's bad to start with, the same information that the examining committee is going to receive, the same information that the attorney appointed is going to receive, all those things, then it can affect how the process goes from the beginning, and it may go down a road that absolutely wasn't necessary because everybody's going to presume some of the facts are true. 2, an unscrupulous or neglectful guardian. How successful a guardianship will be obviously depends on a lot on the guardian. The bad guardians get a lot of attention. For the vast majority of guardians, whether they be personal or professional, are good guardians, and they do what they're supposed to under the law, and they look out for their wards. But it would be completely dishonest to say that the things you hear about, the horror stories you hear about guardians, never happens. It does happen. It happens right here in our local area in Florida and throughout the country. And because in both these factors of the bad faith petitioner and the unscrupulous or neglectful guardian, we're dealing with human beings. We're dealing with humans who are capable of error, who are capable of, misdeeds and deceit and greed and all the things that can create a unsuccessful guardianship. So if you have a guardian who's unscrupulous, who wants to take advantage of the ward's money, who wants to do things that will benefit the guardian's bottom line, such as fees, trying to increase fees as opposed to what may be better for the ward. For example, if a guardian's selling an asset such as a home because they want to use it as a basis to get more fees at the when they make their petition for fees because they had to oversee a sale of an asset, but that really wasn't necessary, and now the ward's lost, a protected asset. That would be an example of an unscrupulous act by a guardian. Neglectful guardians, they don't check up on their wards as regularly as they should. They don't actually ask questions. They don't listen to the wards. If they see bruises, they don't ask questions. They don't watch the person who's managing the money closely. They don't review statements and see that certain things are not right, and they're not being diligent and reviewing these things and treating the ward's money as if it was their own, in the sense of being protective of it and being diligent and prudent. All those things can lead to some problems with the guardianship. It can lead to the ward being victimized. Finally, if there's a lack of funds and resources available of the wards, it can make a guardianship less successful. Guardianships are expensive. We're going to look into cost here in a bit, and you'll see that the cost of having a guardian is pretty significant. If there's not enough funds to begin with to maintain the ward's standard of living, or and maintain the cost of the guardianship, usually what happens, the ward standard of living has to go down. The guardian is not all of a sudden going to start working for free. So sometimes you can see where maybe a ward started out in a facility or stayed in a facility they were already in, and now changes have to be made because the funds, assets, and other financial resources available are dwindling. So if any of these three are in play, you probably are more likely to have an unsuccessful guardianship. They're all things that just lead to pitfalls in the system. Let's take a quick look at professional versus personal guardians. And when I say personal, that's when the court chooses to appoint someone who doesn't typically serve as guardian. It's probably the only time they'll serve as guardian. It's usually a spouse, a child, an adult child, or another loved one, or a good close personal friend, or someone who's willing to serve. The personal guardians oftentimes serve without a fee or a reduced fee. They don't necessarily have any high degree of education or resource, but they're someone that the court thinks the ward trusts, and that the court trusts to look out for the ward's best interest, and has determined that would be sufficient. Then there's also professional guardians. There's folks that are registered with the state of Florida and the Department of Elder Affairs, and they do this professionally. They get on lists to be appointed. They comply with any local requirements, and they have at any given time their guardian for many individuals, and they have a standard bond that most of them have to post. It's I've seen them as low as $25,000. Some of them have $50,000 bonds that they have just as a matter of keeping their license with the state of Florida. And I looked on the website not too long ago, and I can't remember the exact number, but it was more than 100 registered professional guardians in the state of Florida. So those are the two that the court usually has to choose between if it's determined that a guardian is warranted in these cases. So now you kind of understand the differences. What are the pros and cons? Well, professional guardian, I know oftentimes people like the professional guardians if there's infighting in the family. If one son wants to be the guardian and the daughter wants to as well, court sometimes will say, well, let's just go with a professional so we don't cause chaos and tension within the family. Obviously, sometimes there are no individuals that want to serve, so a professional is needed. And sometimes the assets of the ward may dictate that a professional works better. If a ward has a complicated, asset structure, if they have companies, if they own, a dozen rental properties and things of that sort, if there's something that, maybe the spouse is not just qualified to or could properly handle that, they don't have access to, property managers or financial managers that are needed, or maybe business have to make choices about who's going to run the business and things like that, the court may determine a professional has a better chance of doing that appropriately. Now, what are the downsides of professionals? The cost is the main one. It's oftentimes pointed to that professionals have no, personal interest in the ward, and that makes it better because they have no skin in the game, and they have no conflict of interest as maybe a child would, that maybe wants to see things done to hurt the other sibling that they don't like or something of that sort. But I also would point out that a professional guardian has an inherent conflict of interest because they make money off how they manage the ward's assets and how they manage the ward, and there's certain things they can do to increase their fee that they're due. And while I don't think all professional guardians are out there trying to maximize fees, I do think it's just an inherent conflict that everybody would have that's in business to have that underlying issue out there, that when they have to make a decision, is there something even subconsciously driving them to do the thing that would increase their fee. So that kind of gives you an idea of what the balance is on professional and individual guardians, and why it might not always be clear which is better. So what else can affect how successful guardianship will be? Cost. Money is an overwhelming concern. There's a whole plethora of fees and costs that I'll outline in more detail in a later slide. But it's not unusual to get to the table at the incapacity hearing and the guardianship hearing and already have incurred, significant fees and costs. $5,000 would be unusual, depending on the nature of the guardianship. So, and then there's the cost to maintain the guardianship every year. So, if those costs are, astronomical, or they're extraordinary because there's so many issues going on, maybe there's some infighting with the family, maybe there's some business aspects or asset management aspects that makes, having to go have hearings and go back to the judge a lot, driving up the cost. All those, if they're so big, they're eating away the monies that are intended to protect the ward and for the ward to live off of for the rest of their days, that can cause some problems. What's another thing that can affect how successful a guardianship will be? The experience of the professional versus the personal guardians. As we discussed, the professional guardian is going to cost a lot more than the personal guardian, but the professional might have that experience that the personal guardian doesn't have. And while there may be a cost to the professional guardian, that you may save time and you may make more money or save more money if you have a professional who has access to other professionals when needed, where an individual may struggle with that. And then we had discussed the personal interest issue as well. So now we see how professional and personal guardians can affect how successful a guardianship will be in the interplay there. So let's look at this cost I mentioned a few times. 744, Section 744.108 Florida statute governs what fees and costs can be paid from the assets of the ward with a court order. And you're going to find that the language there says, the fees and costs incurred, by the ward's attorney, the guardian's attorney, and any other attorney that, did something to benefit the ward are typically recoverable. So now you're looking at attorney's fees of the ward, attorney's fees of the petitioner's attorney, the person that initiated the petition, whether it be a caregiver or a family member or whomever, and the attorney's fees of a guardian and going forward will be covered. There's filing fees. There's going to be fees, and when you file, there's also fees related to the background check a guardian has to do, and things of that sort. The examining committee members, there's 3 of them, remember, and they have to be paid. Most counties have a chart on that. They have a predetermined amount. There's audit fees every year. When the clerk has to review the accountings and the plans. There's going to be a fee for the bond that has to be renewed every year. And then typically, if you're not a professional guardian, you have to take an education course, and those fees are recovered from the assets of the ward as well. And this is just a few of the fees. I mean, they're depending on the type of guardianship, there can be more. There can be accounting fees. There can be some kind of business consultant fees. There can be appraisal fees, things of that sort. The last factor we're going to look at that determines how successful a guardianship will be is judicial oversight. And as I said before, I think that's probably the most important. How much oversight any particular guardianship matter has probably plays a role into how good the players that are involved do their roles, and the players being the attorneys, the guardian, and the ward, and the people that are taking care of the ward. So, what is the court's role in a guardianship? Well, they do a number of things. They appoint the attorneys and examining committee members in the beginning. They consider any emergency or temporary measures to protect the ward in the beginning. While you're waiting for the determination, the reports to come back to determine incapacity, There may be a need to, to freeze the ward's assets, to keep someone who's abusing the ward, get a protection order against them, things of that sort. The court will hear all of that and determine if they should make some kind of temporary preliminary order of protection before they've even determined if the ward needs court protection and for being an incapacitated person. They ultimately will determine incapacity. The examining committee reports are just evidence. They're not determinative. The court determines that finding. They'll determine if there's any lesser restrictive means available, lesser restrictive than guardianship. Ultimately, if there is a guardian, they'll appoint the guardian. They'll hear, if there's conflicting petitions or requests, they'll hear all the evidence and the testimony and determine who's the best to serve as guardian. And then they're going to have the role of overseeing that guardian perhaps for the rest of the ward's life. If the guardian stays on board that long, they're going to review the initial report of the person in the inventory and make sure there's no issues there. They're going to review all the annual reports and inventory of the guardian, and usually with the help with some clerks and monitors and auditors, they'll review those and see if there's any inconsistencies or points of concern. They're also going to consider requests for extraordinary relief throughout the guardianship, and that may be, like we discussed, some of those statutory things that the guardian cannot do without court permission. And they also they consider requests to sell property and things of that sort as well. So what can happen if there is a lack of judicial oversight? Well, as we just went through those, you can see some of it pre-appointment. If the court's not asking good questions, if the court's not, reviewing the reports, the court can miss things that are important to note. Maybe early on, the court can see that there's evidence that there's a bad faith petitioner, that there's inconsistent, allegations made or something of that sort. And if the court is, strictly overseeing all the petitions and things of that sort before the incapacity and appointment of guardians made, the court has the ability to determine if the alleged incapacitated person is being subjected to things they shouldn't be subjected to. In short, the court's attention to the matter will hopefully ensure that the players involved act in good faith. Post-appointment, after the court has essentially suspended rights, the legal and civil rights of the person, and put someone else in charge to exercise a number of those rights, I think that's even more important to have strict oversight. And if they don't, what can happen? Money can be absconded with, waste can happen. It can end up where a ward who was financially secure is all of a sudden going to be a ward of the state, because they're going to be financially destitute in just a few years if the court is allowing the guardian to incur expenses at such a rate that the ward's assets will not sustain it for any long period of time. If the court's not asking questions, they may be missing out that the ward is being isolated, they're not getting visitors, they're not engaged in any kind of activities, and essentially that the purpose and the rights that we outlined in the beginning, the protections for the ward are being ignored and not given attention to in this matter. So depending on whether it's pre or post, judicial oversight is one of the most important ways to make sure that anybody who is a bad player is sniffed out and that they're shut down as quickly as possible before any harm can be done. So we've talked about guardianship horror stories. What makes up a guardianship horror story? One, the ward runs out of money. That can be really be a horror to someone who worked all their life, had a good savings, had a good, lived in their home that was paid for, had a good means of living the rest of their life comfortably there. Now all of a sudden they've incurred 24-hour care, they've incurred guardianship fees, accounting fees, all kind of court fees and costs, and now they're not able to sustain that anymore, and they have to be either removed from their home or put into a facility. and then they run out of more, and then that's more money, and then eventually they become a ward of the state, and they're in a home that's provided by state, essentially state welfare assistance. That I think most people would say that qualifies as a guardianship gone wrong. Their assets are wasted or misappropriated. Rarely, sometimes people take the money and run. Certainly, they can do that in certain guardianships if there's not been a restricted depository and there's a lot of cash assets, and and to the extent it may be above any bond that was posted. But more, what usually happens is this is a slow process. There's expenses that the guardian's incurring, or there's expenses listed, and they're either not being accurately represented. They're really not expenses of the ward, but maybe the description is said to be, or they're overspending certain things, or taking action that's just not required, and over time that adds up and leads to a destitute ward. What I think is one of the worst horror stories is when the ward's familial relationships are severed, when they lose, because of the guardianship, because they've been moved, because they're maybe upset, maybe because they're confused, maybe because the guardian's just hard to deal with. The family just gives up visiting or gives up reaching out, and that can be one of the worst kind of horror stories, because familial relationships are probably the most things that are indicative of the ward having a good, fulfilling, long life. And when I say familial, that can be also close family, friends, and things of that sort. When the ward loses all their independence, while sometimes it may be necessary, as long as a ward is aware of their surroundings, my experience says that they all want to have at least some level of independence. They want to have some level of decision making, even if it's just even if it's not all that substantive. And when they have no independence, they can't even have a cell phone. They can't even make a decision of who they can visit with or who they'll call that day. I think that's really sad, and I think that's not anywhere we want to find ourselves when we're older and in this kind of position. And then, of course, it turns out to be a horror story if the ward's health declines or they have an untimely death due to the guardian's actions or lack thereof. They've been left somewhere where they're neglected. They get bed sores. They develop, some kind of pneumonia or other disease because of the condition. They have been kept in, sanitary and healthy conditions, and that maybe makes their health decline or could result in an untimely death. Any of those things would obviously be a horror story as well. So let's look at some of the horror stories. And I don't have much time here. I've only got a couple minutes because I want to leave a few minutes for questions. But I've left links here, and they'll be in the handouts that's available too from the interface. And locally, Rebecca Fearley, if you've been in the Central Florida area, you've probably heard about Rebecca Fearley. She's the ultimate horror story. She went unchecked. It seems like that's at least the allegations that are made. I've got some of the latest articles on her case. She's been arrested. It started when in Orange County, when Judge Thorpe noticed that there had been a ward that had a do not resuscitate put in place by the guardian, and that's something that the court is supposed to order. That's one of those things that you should get court permission to do. And she had not, and the ward had not been resuscitated because of it, and the family was complaining. And then when Judge Thorpe started looking at it, she realized she'd done this in other cases, and then there was more investigation, and now she's accused and up on criminal charges related to overbilling and with Advent Health and things of that sort. Figures being thrown out there like in the millions. And then recently, the latest article here, I think, is the one that shows that now that they went back and did kind of an audit, they realized the court auditors may have missed some things that they should have picked up on when they were auditing reports every year. All this is, allegations. It's all currently being investigated, but it certainly is making big news. It gets people's attention. It's exactly what we try not to have happen. So you've got the links to some articles if you want to know what's the latest in that story. And then if you believe it's just one and done kind of thing, it's just not true. It's all around. And as I've said, even when wards and their families complain, even if all their facts are not true. If the ward is completely unhappy and convinced that the guardian and the court is just working to harm them or doesn't care about them, and the family feels that way, that in of itself can be considered unsuccessful. So I gave you a link here, and it's a website where various victims come on and they give their stories either in writing or oftentimes with interviews, and you can pick any state and you can find a story there. And so it's, again, that's not it's a people telling their firsthand story. Sometimes it's the ward, sometimes it's the children of the ward or some other person, but it can get, if anybody doesn't think that this is a national phenomenon, please take a look at that and see that this is a trend. There is a trend of guardianships being used or somehow coming out not to be for the intended purpose to protect the ward. And that's again why we were here today. So thank you for joining me for part one. I know we went through some of these topics a little fast and you know, in very short order, but that's to give us a basic understanding, so we can delve a little bit more next time in part two as to why are these horror stories happening, where are things not being done correctly, and maybe there's some hope to make some changes, and not just here in Florida but throughout the nation to protect folks. And have a good day.